Hello, this is Matt on the Moon Lambo channel. We now know what Ripple is appealing in the SEC v. Ripple case. As everyone undoubtedly has been made aware by now, the SEC, of course, is appealing the Judge Torres' decision in the SEC v. Ripple case, primarily going after programmatic sales, which didn't quite turn out the way that they wanted. Of course, they'd love it if people like you and I couldn't buy and sell our XRP on exchanges. They'd also, more importantly, though they can't appeal this and they aren't, would have loved it if XRP itself were found to be a security. But I have a feeling that things are not going to go so well for them here. And there's a really good chance, actually, that because the SEC did this, which is what prompted Ripple in the first place to cross appeal, mind you, speculation, I don't think Ripple would be appealing at all if the SEC hadn't done it first. But here's the thing. Ripple could end up in a better position because of this. Because there's a really reasonable chance. Well, first of all, I don't think that, for good reason, and I'll explain as we get into the first part of the video, that the SEC could win on their points, but there's a decent chance that Ripple could at least get some additional beneficial wins. So we'll break this down. Now, this just occurred several hours or so ago. So I've got perspective from attorney Jeremy Hogan, attorney Bill Morgan, and a comment also and perspective from Ripple's chief legal officer, Stuart Alderati. Given that's only been a few hours here and it happened a little bit later in the evening, some of the attorneys that I expect that will probably want to comment on this, we haven't heard from them yet, at least not at the time that I'm recording this. But there will be plenty more to say in the future. So it's a fresh story. I'm just going to share with you what we know to this point and what this means for XRP. But before going further, I do want to be clear. I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out and credit to attorney James K. Filan of the XRP community for sharing this. And so this was posted 7:58 p.m. Central Time, so it's been a little over 4.5 hours now as I post this, as I record this video. It is 12:34 a.m. Central Time, which is my time zone. So now it's technically Friday the 25th because it's past midnight, 2024. But still pretty fresh story here. Now, we did know that this was going to be coming. In fact, there is this post from Fox Business journalist Eleanor Terrett, where she noted just that, and she shared some quotes from Stuart Alderati and from Brad Garlinghouse exactly on this topic from a discussion that she had with them just last week in Miami at Ripple's Swell event. So I'm going to share with you this, and then everything else from here is brand new stuff from Stuart Alderati, Jeremy Hogan, and attorney Bill Morgan. So take a look at this. She wrote, when I interviewed Brad Garlinghouse and Stuart Alderati last week in Miami, they emphasized unwavering confidence in a Ripple win in the Second Circuit. So check this out. This is a quote from Alderati. I felt good about our case at the district level. I feel even better about our case at the Second Circuit for a whole bunch of reasons, Alderati told me. The Second Circuit, traditionally, is not a fan of the SEC. They're not a fan of regulatory overreach. And statistically, if you lose, your chances of getting the Second Circuit to reverse is around 10% or less. So I think that, again, I'm superstitious as a litigator, so I don't like to predict results, certainly not guarantee results, but I feel very good about the Second Circuit result. I think it will not only affirm Judge Torres, I think they will go further than Judge Torres. I think they will fortify her ruling. So folks, this is what I'm talking about. I got to pause here to interject here. Spot on. Not only do appeals almost always fail, again, he said around 10% or less have that success rate. This could fortify. This could absolutely go the opposite direction that the SEC would want and help Ripple and further strengthen basically legal perspectives there as a result for the entire cryptocurrency asset class in the United States. And so you'll see why, but let's keep going. So then he says, I think they will fortify her ruling, and then at that point, the SEC will be in the losing position again, and it would be up to them whether they would want to bring this to the Supreme Court. End quote. And then Ellie continues, when I asked Garlinghouse about the possibility of the case going all the way to the Supreme Court, he said, and this is a quote from Brad Garlinghouse, I am so confident that we're going to win the appeal, and that would really put a dagger in Gary Gensler's whole agenda around crypto regulation. Honestly, Ellie, I'm not losing any sleep over it at all. I'm so confident about it because I believe we're on the right side of the law. I think we're on the right side of history. End quote. Oh, yes, they are, and I do not think this will go well for them. So, upon this news breaking this evening, here's what Ripple's chief legal officer, Stuart Alderati, had to say just hours ago. Today, Ripple filed a Form C, listing the issues we plan to raise on our cross appeal. A few things to keep in mind as we move forward. The case is not about whether XRP in and of itself is a security. XRP is uniquely situated as having clarity alongside Bitcoin in not being classified as a security. The SEC is not challenging that ruling, which stands as the law of the land. Okay, at this point, since I've seen him say this more than once, I don't know if there's something, and there may legitimately just be something I'm missing. When did Bitcoin get legal clarity from who? Like what, where, when? What's going on here? It sure as hell wasn't from Congress. It sure as hell wasn't from the SEC. Where does it have this legal clarity? Now, mind you, I don't think that any government entity is actually going to attack Bitcoin specifically. I think it's too far along, too far adopted, so on and so forth. But where's the actual legal clarity? Because you can point to where it is with XRP. Judge Torres literally in court declared that XRP itself is not a security. Where did anything like that happen to Bitcoin? I've not seen it. So I don't know, when people say this, especially given that Stuart Alderati is a brilliant attorney, he's in the know. I wonder if he's saying that because it's effectively accepted as though it's not a security. Is there something that, because I'm not a know-it-all, maybe I am missing something. Is there something from a legal perspective that makes Bitcoin itself not a security? I've literally not seen it. Even going throughout the entire SEC v. Ripple case, all the aftermath that has ensued since then, I've been on top of this and covering stuff. And again, I admit I could have missed something. I really haven't seen anything of the sort. So if that's true, I'll be happy to acknowledge it. I would really appreciate it, actually, if somebody could point me to a source, because I just haven't seen it yet. Anyway, Stewart continues. The appeals court reviews the record that has already been set, and we have a great record. The SEC, and I love this, check this out, folks, I didn't know this. The SEC can't submit new evidence or ask us to produce more, meaning there won't be all the drama we had in the litigation when we fought over documents. So, folks, like, first of all, that should make for a less stressful experience, I would think. But second of all, does the SEC think that given that they can't even effectively make new arguments, certainly not with new documents anyway, do they really think their chances are remotely good? Are they just doing this because they're stubborn little brats? I doubt that they are operating in good faith. I do not believe for a moment, in fact, that they're operating in good faith here. They're just dragging this thing out. But here's the thing. I don't even think that this is going to be good for them. But they so frequently, including in the Ripple case, so frequently made decisions, strategic decisions, that weren't good for them. So I'll not be surprising if this entirely backfires on them. Bunch of little bitch asses. Anyway, Stewart continues. As we go through this process, please remember the SEC's broader strategy. Try to create distraction and confusion for Ripple and the industry. But honestly, it's just background noise now. The hard part of the fight is behind us. Ripple's business is growing and getting stronger every day, even as this appeal process plays out. Spot on, Attorney Alderati. So there are 4 primary points that I'm going to run through with you, and Jeremy Hogan had some things to say about these 4 points. So I'm going to read to you what the Ripple's attorneys actually had to say, and then I'm going to show you what Jeremy Hogan specifically had to say about this, because he had one of the earliest breakdowns of what this means and thoughts and so on and so forth. And so here we'll go to point number 1. Actually, I do want to mention this first. You may see that there are 161 pages listed, and Attorney Filan, in sharing this, wrote that the relevant pages are below, and there are just 2. And the other one's just a typical, I'll show you for those that would look, it's what's on your screen right here. It's just the filing information. And then there's just this, and there's 4 points on it. That's literally it. So why 161 pages? Well, I haven't opened the file myself, but I think it's going to be the same as what happened in the SEC appeal when they ultimately did file. It was something like 180 pages, but almost all of it was because the Judge Torres ruling was attached. So it's a virtual certainty that it's exactly that, or just other documents that have been attached that are relevant. It probably is just the Judge Torres decision, though. So in case anybody's curious, I just thought I'd mention that. But here's point 1 of 4 from Ripple's attorneys. So this would be what they're appealing. Whether an investment contract under Section 5 of the Securities Act of 1933 must have the essential ingredients of A, a contract, B, that imposes post-sale obligations on the seller, and C, that gives the buyer a right to demand and receive profits from the seller's activities. And so, folks, I'm sure that if for those of you that have been following over the last few years, you're probably familiar with the argument Ripple has made that you can't have an investment contract if there's no contract, right? It just seems like common. I don't call me silly. I'm just being a silly goose here. Just call me whatever you want. But to think that you can actually have an investment contract if there's no contract, that doesn't compute to me. Now, fine, I'm a layperson. I'm not an attorney, but just from a pure logical perspective, that doesn't compute. Which is, I admit, of course, separate from legal precedent and so on and so forth. But it still has never made logical sense on the surface to me. So here's what Attorney Hogan had to say. Ripple filed its notice of what exactly it's appealing, which is, number 1, whether an investment contract must actually be a legal contract. In my opinion, Ripple is bringing this issue to the appeals court mainly for the benefit of the crypto space in general, because Ripple's direct sales of XRP were the subject of actual contracts, and even winning on this issue wouldn't help Ripple from having to pay the $105 million judgment against it. But winning this issue would cripple the SEC enforcement regime. Spot on. And so you may recall that when we found out on October 2nd that the SEC had made the decision to appeal the Judge Torres decision, Attorney Hogan said, the SEC has made a mistake, right? In no uncertain terms. He literally said that it was a mistake, and for good reason. It could absolutely cripple their ill intentions of crippling the crypto industry. They could have just let it go. I mean, that was an option, but given the egomaniacs that they are, for that reason they couldn't, but they technically could, right? Point number 2, this is again from Ripple's attorneys, whether the district court erred in concluding as a matter of law that some of Ripple's transfers of XRP met the requirements of SEC v. WJ Howie Co. for an investment contract, including A, an investment of money, B, in a common enterprise, with C, a reasonable expectation of profits solely from Ripple's efforts. And so, folks, I'll just say, and I'll share what Jeremy said in just a second here, but I've always found this to be absurd. I'm glad that we got what we wanted as XRP holders from this lawsuit, but look at these factors here. An investment of money. If you're a Ripple customer utilizing XRP as a bridge currency, given that it settles with finality in 3 to 5 seconds, do any of them consider that a freaking investment of money? It's done in 3 seconds, bitch. What are you doing here? It doesn't make freaking sense. Okay, and then a reasonable expectation of profits solely from Ripple's. How are you going to profit from Ripple's efforts inside of, 3 to 5 seconds? Are you serious? And then if you're talking about a common enterprise, this always goes back to that argument of, is there a common interest here or is there a common enterprise? Because Ripple doesn't control XRP in the XRP ledger. Because it's not centralized. The XRP ledger is decentralized. So yes, Ripple has a common interest with other participants in the ecosystem, just like a jewelry store might have a common interest with a company that mines gold. So what? Common interest does not equate to common enterprise. So this is a part where I think disastrously Judge Torres did get things wrong, but we're not harsh on her typically as a community because it doesn't hurt the typical everyday XRP holder. She did protect us there, but her logic here does not compute so far as I'm concerned. So here's what Attorney Hogan had to say about that. Whether Ripple actually sold XRP as an investment contract at all. This allows Ripple to re-argue all of the basics of the Howey test, right? And so if Judge Torres did get anything wrong in her decision, it's that. And Ripple gets to argue that, which is why when Stuart Alderati, as I just showed you, said, hey, might come out stronger on the other side of this thing, that's why. Right there. Exactly. Number 3, back to what Ripple's attorneys wrote. whether by proffering evidence of widespread uncertainty about the application of the federal securities laws to virtual currencies and other digital assets, and of the SEC's inconsistent and deliberately vague statements about how it would apply those laws, Ripple raised a genuine dispute of fact that was material to its defense that it lacked fair notice that its conduct violated Section 5. Okay, there we go. So that's one thing that I hadn't seen discussed by any attorneys within our community. And maybe I just missed it. It's not like I can see everything that everybody says, of course. But if there was one surprise out of this thing, to me, that would be the biggest one, certainly, that Ripple is pushing back regarding the fair notice defense, which didn't do well for Ripple in the first go-round in the SEC v. Ripple case, but they can bring it back up now because they're appealing, because those asshat pricks at the SEC decided to appeal first, and Ripple just responded in kind here. And so here's what Attorney Hogan had to say. Ripple's fair notice defense is brought back to life. Did anybody see that coming? Now, maybe some attorneys, thought that was an opportunity. Now, me not being an attorney, I didn't know what to think, so I didn't really, admittedly, spend much time thinking about that, other than, of course, like everybody else, I had the expectation that, the thing that was clearly most important to Ripple, the institutional rules, yeah, that they cross-appeal that, but on the other things, like the fair notice defense, I mean, hell, what do you got to lose at this point, right? And then we had this, where to go? Here we go. Number 4 from Ripple's attorneys. Whether the specificity and clarity requirements of Rule 65 of the Federal Rules of Civil Procedure bar an injunction that, like the one here, does no more than to direct the enjoined parties to obey the law. Exactly. So, again, coming from the perspective of someone who is not an attorney, when there's this injunction, and I read it literally as written on my channel at the time, my response was, so basically the injunction is that Ripple, you can't break the law. Well, but the law already exists. Like, aren't they subject to the law regardless of whether you have an injunction that says you can or like you can't break the law? Aren't they subject to that regardless? Yes. And so I always thought that was silly. And the point here, though, is that it seems to be overly broad. So here is a post. Here's what Jeremy Hogan had to say about this. Most interesting to me, Ripple appeals whether the injunction is specific enough when it basically says, follow the law. This seems quite common in securities laws cases, but really makes no sense as an injunction. It also indicates that Ripple would rather not have that injunction hanging over its business. Battle lines are drawn. Exactly here. So that, and then the fair notice, because look, obviously there's not sufficient legal clarity in the crypto space. So the fact that the idea that Ripple knew everything that it needed to obey the law, well, certainly not if you look at what the SEC has charged them with. And obviously they broadly failed. So I love seeing that get brought back up too. There's also this, somebody named Wadhopper wrote, thanks Attorney Hogan, are you convinced that the odds are still Ripple's favor to win 80% asking for a friend? Attorney Hogan said, sometimes win versus lose in these cases is not a clear line, but yes, I think there's an 80% chance Ripple comes away from the appeal in a better position than now. Well, they risked that. Here you have a post from attorney Bill Morgan. I was also surprised by the form of the injunction and how broad it read when the final orders were made. Is this typical? I cannot recall an Australian court, because he's from Australia, ever giving an injunction to the effect of obeying the law. Damn it, Jeremy. So that's point number 4. What? So don't break the law? Yeah, exactly. Why do you even need to say that then? They already do it. And he says, damn it, Jeremy. I am busy at work today, and now I'm going to have to check some cases involving the Australian Securities Investment Commission to see if that is so. So anyway, that's the latest. That's what I'm sure there's going to be plenty more to say about this. These are just the pre-arguments, if you will. But they're going to go into much, much, much greater depth here. But again, just know if you're an XRP holder, this does not impact us. We golden, and we're in the bull market. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.